Good afternoon, everyone. We are so glad you could join us today. We have an awesome presentation for you today on contribution, things to note when settling cumulative traumas with Lauren Coleman and Nasir Adil from our Oakland office. We're going to start with some introductions, and I believe Rob is going to start us off. Rob?
Good afternoon, everyone. Rob Sivkas up here at our Reading office. I've been with B&B since 2014. Actually started down at our LA office and practiced in LA Orange County. Most of my career I've been practicing work comp defense since 1992. So I've covered pretty much every board in the state. So if anyone ever has any questions regarding doctors or applicant attorneys up here in the north part of the state or anywhere else, please shoot me an email or give me a call. Just got back from court this morning, so we are back in person litigating before the board finally. So we kind of missed that. If I'm not before the board litigating work comp cases, I am a big Las Vegas Raider football fan, so I would probably be at a Raider game if I'm not in court. I look forward to working with everyone. And once again, if anyone has any questions or if I can help on any issues up in the far northern part of the state here, please shoot me an email or give me a call. Now pass introductions over to David.
Good morning, everyone. My name is David Lim. I'm the managing attorney here at the Santa Rosa office. Our office services Santa Rosa, of course, San Francisco, Oakland, and Ukiah. So definitely, if you have any questions, feel free to reach out to me. Although I may be unavailable next week, I'm taking my first international vacation in about 10 years, going to Bali. So, but I will be checking emails, so feel free to reach out. Thank you.
Good afternoon, everyone. My name is Nasir Adil. I am with our Oakland office. I'm the managing attorney. Our office primarily covers the Oakland and San Francisco boards. We also cover Stockton as well. I've had the pleasure of being with our firm for over 12 years now. And I don't know if anyone else typed in mashed potatoes, but come on now. Who doesn't love mashed potatoes? You can serve them in any way and any way. Yeah, if anyone has any questions before, during, or after today's presentation, even if it's unrelated to the contribution and settlement strategies we'll be discussing, if anyone has a panel or a PD question or a TD question, feel free to always email me, call me. My contact info is listed at the end of the presentation today. Fun fact about me is that I'm a former non-dog lover who is now a full-on dog lover. I was always scared of dogs when I was a kid, and as an adult also. That's embarrassing, but my daughters love dogs, and I got one reluctantly a few years ago, and now I can't keep away from dogs. So those dog lovers out there, I know why dogs are truly a man's best friend. I'll be introducing the main presenter now, Ms. Lauren Coleman.
Good morning. My name is Lauren Coleman. I am also out of our Oakland office. I have been with Bradford and Barthel for exactly 1 year. And before that, I have been practicing comp for a total of 7 years with different defense firms in Northern California. And I have litigated cases from Stockton up to Santa Rosa. So my fun fact about me is that I also could eat tacos every day, and I'm actually going to Cabo San Lucas next month for a week, and I intend to do exactly that. So I'm excited for that. For now, though, we'll just jump into our presentation about contribution. Okay, so here is the team and our contact information. You guys know our email addresses and how to get a hold of us. If you have any questions about this webinar or really anything else in general. Okay, so first there's an overview of contribution. What is it, right? So basically contribution applies when there are cumulative traumas where there's more than one defendant. There needs to be multiple employers or multiple insurance carriers, which is why it doesn't apply to specific injuries. Usually there's only one insurance carrier per day at least. So I want to make a distinction here against reimbursement and contribution. They're also often associated, sometimes used interchangeably, but there is a key difference. So first, reimbursement covers amounts previously paid on a claim, subject to proof, usually medical reports and a benefit printout. But it can apply across claims. So if you, for example, had an earlier claim, a later defendant ends up paying on your body parts, they can still seek reimbursement from you for your claim, even though you are not in their later claim, if that makes sense. So it's a little bit different than contribution. There's a little more protected, so you're more likely to get reimbursement for amounts paid than you are contribution, because contribution includes all amounts paid to settle a claim, including future medical treatment, and the things that are more speculative, like when we settle out, there is a right to reopen if we're settling that out for an amount. All of that is included in contribution, but it would not be included in reimbursement. Also, they are covered in different labor code sections. So reimbursement is subject to WCAB jurisdiction, and it's pursuant to Labor Code 5300A. And there is a case called the Kroger Company, DBA Ralph's versus Marquez in 2016 that confirms that jurisdiction. Contribution is pursuant to different labor codes, 5275 and mainly 5500.5, and all disputes regarding the right to contribution specifically are subject to arbitration and cannot be heard by the WCAB. So that is a key difference here, because you could file a DOR for reimbursement, but you could not file one to cover contribution. So what is at stake when we're talking about contribution? Obviously, settlement value. Usually it only comes to play when we are settling a case. Once one defendant settles a case, they obviously want to get paid, and for everything paid out on the claim, including the settlement, by the other co-defendants. The concern about contribution specifically is that you can only get contribution if you rightfully resolve liability for all other defendants. And that issue is really the core of what we're here to talk about today. So if the liability for a defendant is not resolved, they remain on risk. And in theory, the applicant could still come after them for additional benefits, even though the case has been resolved. Reimbursement can also be sought pursuant to 5500 with proof, but co-defendants will have a strong argument against paying any additional costs if they were not properly joined or contribution was not properly sought through a petition for contribution. And the entire process is what we're here to go over today. The other thing that is at stake is litigation costs. So if we are not clear about our intent to settle the case on behalf of all defendants, we can enter in litigation about whether they are included in the settlement, whether their liability was resolved, whether they owe you anything, and all of that can be heard by the WCAB, which means that that's going to be DORs, that's going to be conferences and potential trials, just to figure out what is covered by a settlement. And of course, you want to avoid that extra cost. So we'll start off with some 5 questions that we should ask if you're settling a cumulative trauma. First, which should be asked at the beginning of any claim, are there multiple defendants? Second, you want to ask, have all potential defendants been joined? Because settlements, as we'll talk about a little later, can only apply to joined defendants. Was there an election? We will go into this later as well, but that's when one defendant is selected to administer the claim. And then finally, are all defendants signing on the settlements? Generally, the answer to this question should be yes. As we all know, there are sometimes defendants where they are non-responsive and we can't always get their signature. We will discuss that as well. And then finally, has a petition for contribution been filed? And when is the deadline? I would add to that. Okay, so first I want to talk about joinder. This speaks to the first 2 questions. Are there multiple defendants? If the answer is yes, then you want to get them all into the claim. Half the time you will be joined into a claim. So joinder is covered by CCR 103382, and that allows the appeal board to order joinder of additional parties who are not named in an application whose presence is necessary for the full adjudication of the case. More specifically, they can join any person, or in this case, mostly employers or insurance carriers, for whom any relief and benefits is alleged to exist. Now, it's important that it's alleged. So you can basically join anyone you reasonably believe should be a defendant in the case. I think we've all been there when we're joined to a case, we have no coverage and we know that, but the co-defendant didn't know that, so they're just joining everyone. There is a reason for that practice. There is a subject to a 10-day notice requirement, so it can't be issued within 10 days. The judge has to advise that he will be joining a party. They have 10 days to respond, and if they request, they have a right to be heard, which means a conference will be set. It's important to note when parties are being joined. So only defendants joined prior to a first hearing may participate in the proceedings and discovery. The liability of defendants joined after that first hearing will be determined on supplemental proceedings, and they're instituted pursuant to 5500.5. So what does that mean? That's contribution, right? So if there is, for any defendants joined after the initial hearing in a claim, their rights, whether they are liable for contribution, what their coverage period is, all of that is subject to arbitration after the case in chief has resolved. And as noted earlier about whether it's allegedly likely to exist, whether the person is a proper defendant, when in doubt, just file a petition for joinder. I think we've all been there when we get joined and we kind of have to fight our way out of a case if we are not a proper defendant, and we can do that to other parties as well. And I do recommend it because it's always better to be safe than sorry and have too many parties than too few. So, and a lot of that comes into play with elections. So pursuant to Labor Code Section 5500.5, it allows an applicant to select one employer, more commonly an insurance carrier and TPA, who will administer the claim. Once the election issues, that means you guys govern litigation, discovery, the proceedings, settlement. This also means that it empowers the one defendant to settle the case on behalf of all joined defendants at the time of settlement. It also applies, the language of the statute says employers, but it also applies to insurance carrier, and generally it is an insurance carrier rather than an employer that will be elected against. There are limits on elections. An election can only be made against a defendant who was joined prior to the first hearing. This is careful to consider in cases where you have a very small portion of the CT period, but perhaps you were the last defendant, which means that you were named on the application. I know sometimes we can be quick to try to file for a hearing to make sure that we're not elected against, or it's not, there's a better defendant. You just want to make sure that before that hearing, you've joined everyone, because then they can elect against the other defendant with the biggest share of the CT period perhaps, and you can kind of take a back seat until settlement. However, if you join them after the first hearing, there's going to be more difficulty in doing that, and you may end up being stuck administering the claim. Similarly, there's no elections against SIGA if there's any other insurers available in the cumulative trauma period. Judges have the discretion to decline an election and select a carrier to administer the claim. So most commonly, this will happen if the applicant, for some reason, tries to elect someone with 2 days of coverage in a CT period, and there's another defendant with much more of the period. Similarly, they may elect a carrier to administer a claim when we've joined a defendant who's non-responsive. It will essentially grant them the right to settle the claim on everyone's behalf and kind of insulates them if they try to, the non-responsive defendant later tries to claim they had no notice. And then an order approving election is subject to removal. So it can be set aside if you disagree with a judge's selection of an elected defendant. The effect of an election. So once an election is made, the settlement of the case with the elected defendant resolves liability for all defendants. Excuse me. So this means that resolution with one party resolves it for all parties.
Hi, Lauren. I figured your water break might be a good time for me to interject. We have a good question actually out there that's relevant to the topic from Jeffrey Nell. Jeffrey, thanks for the question. The question is, if joined by a party that is elected against, can the joined party still participate in discovery? So in this one, an elected against co-defendant joins another carrier who obviously is not elected but joined. Question is, can the joined defendant, the unelected co-defendant, still participate in discovery?
Usually not. But just so you know, in these limitations, and again, as you know with workers' comp, there's always levels, and one of the more specific levels is that you are allowed to conduct discovery in any of these scenarios if you are specifically going to depose the applicant or you're challenging employment. So even if you're not the elected against defendant, if you're trying to claim that the applicant never worked for you and you want to depose the applicant on your own on that kind of issue, you're allowed to, regardless if you were joined after the first hearing, regardless if you're elected against. So you still have basic, extremely limited discovery rights. However, if there has already been an election and they are just joining you, no, because of the election, they have, as long as they noticed you, and usually they'll do it as part of your joinder, but as long as there is an election, no, you have to take a back seat until the case in chief resolves.
Yeah, like Lauren said, most of the time the answer is no. In fact, you're even at hearings, you're usually not really a party even attending a hearing as a later joined non-elected against co-defendant. So most of the time, unfortunately, no. But like Lauren said, there are a few exceptions. Thank you for the question and thank you for the answer.
So once an elected defendant settles a case, the effect of that settlement is that all employers that are joined parties are jointly and severally liable for any settlement award that issues. So that language is important because that means we are all liable for the entire settlement, which obviously wouldn't be the case, right? We have arguments against our coverage period. He was only working for us for X number of days, but all of that would be formally, hopefully informally resolved, but if not, it's all subject to arbitration. And whether an applicant has elected against a specific insurer will often determine whether a settlement resolves an entire cumulative claim or only a portion of the claim. So there are rare cases where you have the right to settle out just your liability for your portion of a cumulative trauma claim. These kind of cases are extremely rare, but there would be a case where you have a defendant who doesn't want to settle, but you do. Usually the applicant's P&S, it's been a long time, you just want to close out future medical. Even that's hard because there's multiple defendants, but in theory, you can technically reach an agreement with the applicant to settle out just for your insurer, and the rest of the claim remains open. Something to note about an election is despite the rights to settle on behalf of all of the co-defendants that you have, a petition for contribution is still required. So when you have a CT, you're looking for three things. There's three words that should be associated when you have a CT. That's joinder, is everybody in it? Election, is there one of us designated to administer the claim? And a petition for contribution, because you need to file that to reserve your contribution rights, even if you're an elected against defendant. Okay, when and how to elect. This is active and applicant, usually AA. So there's really not a lot of rules as expected. There's no prescribed time frame. There's no form required. They need to only clearly express intent to elect against a given party or parties. It's usually in a formal pleading or a letter, but it does have to be properly noticed. So usually it's going to be in a form where there is a proof of service so that if there's a dispute later, we can show that everyone was on notice that there was an election. Something else to notice, I know a lot of defendants, carriers in particular, can be a little trigger shy on being elected against, but you can make an election in settlement documents. This is important if you have a case where you have a non-responsive defendant, because if you include the election in the settlement documents and you serve them and they're on notice of the election, you now are allowed to settle on their behalf, and then it makes the contribution portion a little bit easier, even though you will still have to track them down. What if there's no election? So without an election, there is no presumption that settlement covers liability for any defendants other than those who sign the documents. So also in theory, if there is no election, you are still covered if all of the defendants that are joined sign the settlement documents. This is generally recommended, it's good practice, but if there's any situation where your client just wants to get it done and they're, not elected against, there are concerns that you should raise about that and try to get everyone to actually settle. It is worth delaying a settlement to get everyone's sign on because it really helps contribution later. If there's no presumption, that doesn't mean that we can't argue it, but obviously presumptions are nice because they reduce litigation. So if there's no presumption, the default is that liability remains open for all defendants who did not sign the settlement documents. That means that your right to contribution is severely reduced, because your right of contribution is based on the fact that you have resolved everybody's liability. If liability is not resolved, obviously they can still be sought for medical treatment, for additional benefits, so they have no incentive or real reason to reimburse you for what you paid, because they are still on risk. Okay, so the case that kind of guides elections and whether when there wasn't an election, it comes down to intent. So in this case from 2016, Verdulis versus Inc. Systems, the National Fire Company of Hartford, adjusted by CNA, entered into a compromise and release for 3 cases, including 2 cumulative traumas. After the OACR issue, the applicant attempted to elect against another defendant, American Insurance, for one of the cumulative traumas that were included in the CNR. Because there was no evidence that an election had been made and no other expressed intent that CNA intended to administer benefits and resolve the case on behalf of American Insurance, the WCAB determined that CNA had only resolved their own liability and not that of American Insurance. Since American Insurance still had liability, they could only seek contribution, CNA could only seek contribution pursuant to Labor Code 5500 for any amounts paid to the applicant for the CNR that it could prove were paid for any period of the cumulative trauma covered by American Insurance. So what does this mean? This means that you can, again, we can seek reimbursement. We paid X amount of benefits through the benefit printout to the applicant. You had 50% of the CT period. You owe us 50%. That's not a problem. But because the more speculative costs, future medical treatment, the right to reopen, anything else that we're settling was not settled on behalf of American Insurance, there's no right to reimbursement for that. Basically, American Insurance would be on the hook for reimbursement for their share to CNA, and then they would now have to go and settle the claim separately with the applicant. So this case also pretty much emphasizes when there is no election, not all is not lost, but it is definitely an uphill battle. So the main question is, even if there's no election, was the settlement intended to settle liability for all defendants? This is a contract law question. And in Verdulis specifically, the WCAB determined that there was no evidence to show that the settlement expressly intended to resolve liability for all defendants other than CNA. So how do we show intent? If we get in this situation, we didn't do an election, settlement's already done, and now we're arguing over contribution, a co-defendant saying, our liability wasn't resolved. We're saying, yes, it was. We have to show intent. So this has not been an issue that has been explicitly addressed by the WCAB yet. We kind of only have cases where this isn't enough, that isn't enough. We haven't had a case yet that says this is enough. I think probably because those cases settle. But potential ways to show intent would be clear language in the settlement document outlining that this resolves all defendants' liability, including any of the parties. You would want to list specific carriers, TPAs in that language. Filing a petition to contribution, that would show that you're reserving your rights to contribution per your petition to contribution. So then if you had filed your petition for contribution, you list all the co-defendants, how much you paid, how much you want, and that can be incorporated by reference into a settlement, and that can reserve your rights. And then finally, simple notice and acts. So you can send a letter to the co-defendant saying, we're going to solve the case for everyone. We sent you the settlement documents, you haven't signed them, we're tired of waiting, we're going to move through with it. With a proof of service could be enough because you've made efforts to show that the other co-defendants were aware that you are intending to resolve their liability. That's another way. Okay, so what happens with unjoined defendants? Yes.
Trying to interject at the right time, right between your slides. Thanks, Lauren. Just got a few good questions out there. One question that came in from Paula Dean was, can the lead co-defendant be in charge to copy all defendants? I can go ahead and grab that one. Basically, when there is proper joinder, the co-defendant then becomes on the address record. So assuming that there is properly joined co-defendant, that carrier will then be on the address record. So then whenever the address record includes all properly joined parties, then whenever there's notice given, I'd say 9 out of 10, if not 49 out of 50 times, the lead co-defendant will have notice to serve all parties on the address record. So that will include all board-related documents. So they will have the duty thereafter to provide all documents to the notice to the proper parties. I hope that answers your question, Paula. If not, feel free to email me or Lauren later. And Lauren, another question that came in, that's a really good question, fantastic question actually, was when some attorneys out there recommend early settlement. So the specific question was, hey, joinder has not yet happened, so pre-joinder, and sometimes attorneys recommended claims, hey, we haven't been joined, but let's do an early exit settlement. So try and avoid discovery costs. Should we do so? So Lauren, what do you think about that?
So I'm sorry, in that, you're not joined yet, or you are joined?
Correct. The question was not joined yet. That's by, I apologize if I'm mispronouncing, but the question is from Aber, A-B-E-I-R. Good question, Abby.
Yeah, I think that you can do that. I mean, again, so that actually falls under the liability resolution. Like I told you, that's kind of a rare case where you always have the right to settle out your own liability. And there's not a lot that the other co-defendants can really do about it. It's just not usually done because there's always concerns, at least from judges, about adequacy, right? So all the same standards apply to those settlements that apply to any early settlement. So you may run into more issues with that as far as it might be suspended. That might be when you want to walk through because you want to talk it over with the judge. But those concerns aside, yes, you could technically resolve your own liability if there's a claim. So that's the thing. We run into this issue a lot. We kind of want to prospectively settle claims. During a deposition, the applicant mentions a new body part or something. It's really hard for us to resolve a claim if we have nothing, right? But if you have a claim and you haven't been formally joined into the action yet, that's a good time to settle. But if you have nothing, but you know you're going to be joined in, it's really difficult to settle when you have like no claim number, no case number. But if you have a claim number, you could go ahead and do it. And then just, again, it's a notice issue. So you want to just make sure that everybody knows what you're doing. And when you write the settlement, you're going to have to reference the ADJ number. So obviously this comes into our duty of candor. We have to let the judge know what we're doing. So you may end up getting joined, or there may be a settlement conference on it, but you can certainly do it. So I think on paper, it makes a lot of sense. I think in practice and how it actually ends up proceeding through the WCAB is another question. But yes, I think that's allowed. And if you settle out your liability, there's nothing they can do about it. If you've paid because your duty is to pay the applicant. But the issue though is they may still seek contribution for you for any benefits paid prior to your settlement. And that would be subject to your coverage period. So if they did pay, just like in any other case, if you're getting in early, but they've already paid for some medical treatment visits, they may still be able to seek reimbursement for your portion of that medical treatment until the day you settle the case.
I think Lauren hit a good question, Abby. I think Lauren hit the nail on the head. I think you can settle it early, and I recommend the same oftentimes, but you have to be careful on how early you do settle your portion, because it's extremely important that you get all the right ADJ numbers listed. If you settle too prematurely and you don't have the right ADJs or claim numbers properly matching your exposure, then you're not settling out all of your liability. So defense attorneys who recommend that in claims, absolutely great way to avoid discovery and litigation expenses, but do it at a proper time when you know which claim matches your exposure and your ADJ, so everything can be properly listed. Otherwise, you're not closing out all your exposure with your CNR, and who wants to have any more exposure after you already settle your claim? So thank you, Lauren. Thanks for the question as well.
Mm-hmm. Okay, so speaking kind of to that question, unjoined defendants. So the express intent to settle liability can only apply to parties. So that means that it doesn't apply to any unjoined defendants. So the same case, so a similar case, Ventura versus Dana Point Cleaners is another case that's big on this issue. So in that case, there was a settlement document that expressly had the language that I think should sound familiar to everyone: right to contribution from any and all agents, assignees, TPAs, insurance companies, during the CT period, including but not limited to zenith. We all include that language thinking that it covers our contribution rights. Unfortunately, it does not. You still need to file a petition for contribution. And in this case, the WCAB determined that the language was insufficient to reserve contribution rights because Zenith was not a party at the time of settlement. Settlement can only apply to party defendants. Even if there's an election, you can only settle the case on behalf of joint defendants. So what does this mean? If you take anything else away from this settlement, from this presentation, when in doubt, file a petition for joinder. They can show pretty easily why they shouldn't be a defendant, make them do that just because you want to make sure that you're not losing out on any reimbursement or contribution rights because the order of operations on your settlement was not right. So petitions for contribution, what do? They trigger proceedings for apportionment or the right to contribution pursuant to code 5500.5E. Generally, an actual petition for contribution must be filed. It doesn't have to be very in-depth, but you maybe at least want to reference the amounts paid, kind of the range of what you're looking for. If there's co-defendants that you're aware of, you want to mention their coverage period, and there is a time limit. So there is a time limit of 1 year from the date of an award. Now, this big asterisk I want to put by this is any award. This includes intermediate awards. This includes awards for TD benefits if the issues are tried prior to the issuance of a final award. So there's a case from 1997, the Rex Club versus WCAB. In that case, there was a preliminary TD benefit award. The issue just of TG for a specific period was tried. 3 years later, the case resolved by OACR. Within 1 year of the OACR, the elected against defendant filed their petition for contribution. So in this case, we are talking about SCIF, so they were an elected against defendant. So the findings and award issued for TD in 1989. In 1994, the CNR issued. Later in 1994, so within that 1 year period, they filed a petition for contribution seeking reimbursement from co-defendant, the Rex Club, for the value of the CNR. The Rex Club opposed the petition, arguing that it was untimely because it issued more than 1 year after the initial award from 1998. On appeal, the WCAB split the difference. Basically, they said the petition was untimely for the 1998 award, but timely for the 1994 OACR. This meant that we had even more, litigation and things to show because now SCIF could not seek reimbursement for the TD benefits from the 1989 award, but they could be reimbursed for the amounts from the 1994 OACR that did not cover TD. This is really tricky. It should be relative. Luckily, the findings and award from 1998 only covered temporary disability benefits for that period. You know the amount, it's finite. As long as that's not included in your OACR, you know that you can basically get the value. So in this case, they could technically seek almost all of the value of the OACR because likely the TD benefits were not included. But still, you don't know that the value in 1989, there's no cap on TD, so it still might have been a sizable amount of money that was lost. The lesson here is to file a petition for contribution in CT claims following any award. I would even say any order. So if we agree, we've done it, kind of quick at an MSC expedited hearing. We agree this is the TD rate. We're gonna pay this from this, ongoing. Any of that, I would still file a petition for contribution. If there's multiple defendants, just file it. And then once you have an OACR, you can do an amended petition, a new petition. You just want to make sure that after every big event, like an award or an order where benefits are paid, that you are reserving your right to seek reimbursement. I think we all have cases where we've done, maybe it was a specific, so there wasn't a contribution issue, but we've had a TD award, a year or two goes by, then we settled the case. If it had been a CT and we didn't file a petition for contribution, the co-defendant could argue that they don't have to pay their share of that TD payment, which would be unfortunate, right? So now we're gonna step to the other side of the case here when contribution is being sought against you. So when you receive a petition for contribution from your client, First and foremost, you always want to check if there's an election. You'll find that a lot of the time there isn't. But if there is, then obviously we proceed as if they've resolved all of your liability, proceed as if you have to pay, and then highlight that to your client. It's a different kind of arena. There's an election, there's less we can do. Then you want to confirm exactly what I just talked about. Have any awards issued? If awards issued in the past, you want to pull that WCAB file. You want to see what awards have issued and whether the petition for contribution was filed within 1 year of those awards. And then generally though, keep in mind that this is a tool to reduce, not eliminate contribution. Generally, contributing to a reasonably negotiated settlement is in your client's best interest. There always are concerns that liability is open and like, what are we gonna do if the applicant comes after us again? But we all realistically know that that probably won't happen. You know, the clients or the applicants think that they've resolved their case. So why would they try to dig into it if they received this sizable chunk of money and come after another insurance carrier, right? So if you pay the co-defendant, if that, in the event that that ever happens, you have a stronger argument, especially depending on the size of the award paid, that everyone kind of understood that your liability was resolved, right? You kind of paid your share, the applicant was substantially compensated, even if it's not strictly written correctly, the WCAB will probably find that, you know, your liability is resolved. But if you try to fight it and pay nothing, then that's going to be a harder issue and harder to argue later. So really, you should try to contribute, obviously as little as possible, but you still try to contribute something because that's usually going to be less than litigating on all of these issues. And so really, it's just that the lack of the election and clear language of intent in a settlement document can serve as a tool to reduce exposure for contribution, especially if the order of operations was correct. So you were joined, but you may have not have signed the settlement documents, but you were noticed, everyone knew you were on the claim at the time. You know, it's kind of reasonable to think that your liability would be resolved, even if strictly it wasn't, but everyone will usually cooperate as if it was. So you still want to just contribute, and this can serve to limit your liability because they will have to then pay, if you were successful, they have to pay the litigation costs and they get reduced contribution in the event you are right and that your liability wasn't resolved. But it's only kind of a half victory because if your liability is not resolved, now you have to go and resolve it, right? Okay, so then that's really all of my pre-prepared content. I did anticipate that there will be some substantial questions on this issue, but I did provide for your reference a reference sheet. So if you want to know about contributions in elections, it's 5500.5. Limits on elections, there's a case that the shrimp case that covers, you know, what these limits are. There's a standard of review question. This doesn't really come up. It's really kind of a brief issue that attorneys will cover, but there is a standard of review for elections. The effective no election is the Verdulis case. The settlement limited to being parties is on the Ventura case. And then we've got joinder and petitions for contribution. So at this point, we can take questions.
All right. Thanks, everyone, for the continued questions. A lot of good ones out there. One question is, does the first hearing include as early as a DOR declaration of readiness filed for expedited hearing for coverage or medical type of issues?
Yes. The answer is yes. So that's another issue that if there were no questions, I was going to flag. So that's a thing. You do want to there's always this balance in workers' compensation cases, right? If you are a wrongfully joined defendant, you have no coverage. You obviously want to get to the court and get dismissed as soon as possible. However, you do want to be careful because we all know that judges are reluctant to dismiss a defendant when it leaves no other defendants. So you do, to the extent possible, want to try to join at least one other proper defendant before you file your DOR for the first hearing, because then the applicant can elect against them and you can get out pretty cleanly. But if you just try to tell the judge, no, you know, we're just not in it, and you have that first hearing, things get a little bit more complicated because technically the applicant can't elect against any of the other defendants. But I think that would be a situation where the judge would allow it, just because if you get dismissed and everyone's joined after the first hearing, they should be allowed to elect against someone. But yeah, you do want to just be careful about the timing. And yes, it does count for any hearing. There is no specific type of hearing listed in the labor code. Again, I think it is subject to reason, but technically, no, there's no exception for coverage disputes.
Everyone needs to be aware of it can be very early, so everyone needs to be aware of that first filing of hearing. That could be really any point in the case, even as the question pointed out, if it's super early, even for coverage or super early medical treatment issues. Thanks for the question. Thank you for the answer. Another question is, it pertains to the Lorenzo Arevalo case. I believe that's a 2022 case. Does the Lorenzo Arevalo versus Limonera case strip the judge of the ability to recommend election against the carrier/employer with the most exposure?
No, no, it's just that case just kind of, like I said, it's all subject to removal, and like these are just intermediate orders. So none of them are considered final. So any decision, the judge can make a reasonable determination. I think the issue there is that in that case, the facts were a little bit different, right? So I think if anything, that case just kind of speaks to the fact that because none of the true issues here have been tried, you need to have a little bit, it has to be a justified decision to elect. So they can't just say, oh, you have the most days, it's you're elected against. There has to be more to it than that, because especially if there's an argument that you actually didn't have that much coverage, or there was, a specific insurance policy, like all of those issues can come up. So it's really more of like a depth of analysis question. It doesn't necessarily strip them of jurisdiction, especially because all of the decisions have to be consistent with the labor code, and anything that would render the labor code obsolete is not allowed. So they have it has to be read consistently, so it can't be read as stripping them of that power. It has to be read concurrently. So if anything, it would be a limit on their ability to elect. But honestly, in my experience, judges aren't eager to issue elections. They really only want to grant it in a case where, I have a couple cases where it's specifically federal insurance. They don't, respond. They don't show up to hearings. In that case, the judge may order an election just so that if you settle the case and they have not, appeared yet, that they are still joined into your case. It's more of a tool to use to make sure that contributions allowed. I haven't seen too many judges that are really eager to issue elections on their own.
Point taken. Yeah, judges, they tend not to want to overwork. Not to say they're not hardworking, but they want to keep away from this stuff as much as possible. They want to kind of keep their hands clean because they have they don't really have a dog in the fight, and they want to make sure that they try to have the parties resolve that as informally without their involvement as possible. Thank you for the question. Another question that's a little bit broad, but I want to make sure I understand it. The question is, once you file a petition for contribution, does that protect your right to seek contribution on all subsequent, on additional awards? So once you file a petition for contribution, does that protect your right to seek contribution on later additional awards?
I mean, I think that's tough. I would say yes. I mean, I think once it's filed, it's filed. I mean, the other thing I would just note is that you can't just file them preliminarily, right? Like it has to technically be after an award. We can't just like join a bunch of people, file a petition for contribution and say that resolves all of our, that reserves our right. I mean, I think it definitely helps, but I would probably revise it. I would probably submit a revised one, even if it's the same pleading and you just add numbers up. You want to make sure of two things, because the other thing too is all notice. I know we got an early question as like, does this defendant have to notice everyone else? A lot of the time you want to, right? So you don't want any arguments that we didn't know how much was at stake. We didn't know any of this. Like, so you want to keep the numbers and values updated. So when you're in front of an arbitrator or a judge on these really high ticket cases, that you can't, like, you notified everyone along the way that you owe this, $50,000. Now it's $100,000. Like, you want to keep them updated, and the petitions are good ways to do that, just to reserve the fact that like this isn't, the costs are adding up. We're asking for more and more as things happen. So I would do a revision. I mean, I think if you settle and you forget, I think that it might be okay, but technically it does have to be within a year of the award at issue. So I think they may be able to argue that because this award came after, that it wasn't filed within the year. So I would just do a revised, but that's probably, I think it's always safest to just do it after every order. They don't have to be very detailed.
No, I agree. I think the best way to handle claims, either from a claims examiner or defense attorney perspective, is to file petitions early and as often. So obviously file it early just to preserve your rights. And if you need to file a subsequent amended petition, because obviously if you're elected against, sometimes you often have increased TD payments, increased med legals, increased treatment costs that aren't going to be the same as it was, 6 months ago when you first filed the petition. You want to amend that as often as possible, just to kind of keep everyone current. And when you're doing that, you're also instilling your rights for recovery as well. So file that petition as early as possible and amend it whenever necessary. So preserve your rights.
Yeah, the only other thing I would add too, just to it is all contribution, but to keep it cleanest too, you also just want to keep track of your past petitions, right? So this is kind of an issue to use against applicants' attorneys as well. That comes up, I know, often in my cases where they file a petition for 5710 fees and then you settle the case. And then after the case is settled, they come back and they try to say, well, I filed this petition for 5710 fees and I never received it. And then I just say, you know, we settled all issues. So you just want to make sure that you reference at the very least, I would reference my other petitions in my most recent petition. Because basically what you want to do, like in the TD, in that case, the Rex Club case with the TD benefits, if you resolve TD in the OACR, I would argue, I mean, like AA or the co-defendants could argue that you resolved the TD issue. So you'd want to reference your right to seek contribution on the TD in the past, even though it's now resolved by the CNR. So you just want to make sure that you are keeping kind of a tally of all these awards to make sure that even if, you know, you're settling for like new money, you still get reimbursement for all of those costs. It's always just to be better with protective language.
Thank you, Lauren. Another question that I believe Lauren already touched base on in her presentation, but it's always good to make sure that we're all on the same page. But the question is, do we need to have the election from the judge?
No, it's an election. It's really just a document made by the applicant. There actually technically isn't even a requirement that they have to file it. So it just has to be noticed and served. So you just so what'll happen usually at the end of these cases, the case of these years, like, you know, these cases that are resolved now from 2003, we're all trying to dig up, right, an election. I have this, the inspiration for this presentation was actually from this case, but we were all trying to look, like we're going through years of correspondence, like did we get an election? Was there an election? So no, it just has to be a formal indication that says, you know, applicant hereby elects against so-and-so. And then you just have to be able to prove that it was served on all the parties and that everybody was noticed. That's it.
And oftentimes that even goes, it can be so informal as even in the minutes of hearing at the bottom, it'll say, something, a one-sentence statement that says applicant elects against blank carrier. As soon as that's served, even though it's not on formal plating, that's still an order that is, it's the most informal formal document. But to answer your question, it can be very early. And that goes for unrepresented and represented cases. Is that correct? That's another question, Lauren, for elections with unrepresented and represented workers.
Yes, I've never seen an election in an unrepresented case, but yes.
Pretty much crosses over, correct? We have a few minutes left. We're trying to see, might have been one or two more questions. My apologies if we didn't get everyone's, but if there was a question that you did not get answered, or if you think of a question at 2:30 today that you may have not asked already, email us. We want to make sure that you get these questions answered to the best of our knowledge and go forward. Sorry, I'm trying to scroll through, see what else I have.
That's no problem. We have a few minutes left, so I'm gonna go back now that we've kind of covered all of the material to those 5 questions, because if there's anything you take away from this presentation, it would be this slide with these 5 questions that really should, when you get a CT, if you wanna like write these down, screenshot this slide even, when you get a new CT claim, these are just things you wanna be thinking about from the beginning of the claim, and the earlier that you think about it, the easier it will be later down the line, because we've all settled cases that involve these issues without there wasn't necessarily election, there wasn't a clear petition for contribution. Like, with our high volume of cases, we can't all reasonably anticipate perfect practice on every file. But you still want to just keep these things in mind, because the closer we get to it, the easier it'll be down the line. Because a lot of the time, I think we've all been there when we get these, once the case is settled, all of these arguments start coming up only in contribution. So you want to try to get them resolved or leveraged while the case is still live. It can reduce settlement value. It can increase, a co-defendant's contribution to a settlement. So you don't even pay, you pay less upfront. And, it's just good practice to going forward, because especially the question about all defendants signing the settlement documents, That's a big one. Like generally, you just want to do it. I know that SCIF is a major, like almost all of my contribution cases where I've had to make these arguments, SCIF was a party. And as you notice in a lot of the cases you'll see for these cases revolving contribution and elections, SCIF is a party. They're kind of the only real big defendant that I know that actually will unilaterally settle, issue settlements without consulting the other defendants who are on the file at the time. They also will sometimes accidentally settle cases that they are not parties to. So you just want to be careful with that and really just try to get everyone sign on if they're not being responsive. I think it's even worth it if it's multiple defendants that you file a hearing. Like even if you can't get a hold of them, just file for an MSC. And if they don't, explain it to the judge. If they don't show up to the MSC and everyone else is willing to sign, I think that's going to get you a lot further as far as being able to reasonably seek contribution. You put in the effort, the due diligence to get the settlement done. So that's kind of these 5 points are really what you want to think about whenever you have a case involving contribution. So.
Thank you, Lauren. And one last question, and we're down on time, so I'll answer it really quick. The question is there any benefit to an applicant denying that a joined party be involved? So does applicant have any benefit to really objecting or denying to a joinder? The answer is really case specific, but of course that's a legal answer. But in practicality, there's really little benefit. And the reason is because the threshold to join a carrier is very low since it's early in discovery. As long as there's some basis between coverage or whatnot, you're probably going to get joined. And most times in applicability, the applicant attorney, the applicant, they're not really going to object too much to a joinder of a defendant, just because it means more potential for them getting paid, frankly. So there's really little incentive for them to object to really joinder. It's possible, but unless if there's a really solid reason, it's probably not going to happen.
So there's also case law. I did not put it in this presentation, but to that point, and you can email me if you have this as a case specific question, I can find the authority for you. But there is a case that says that a defendant cannot be dismissed purely because the applicant says they should be. I guess so basically, if this would come up in your early settlement cases, and this is kind of what me and Nasser were touching on that issue, is if you settle a case before you're joined, and then as a part of that settlement later, they try to join you, and then the applicant tries to say like, oh no, they shouldn't be joined. There's cases where the judges have tried to dismiss them, the applicant saying he didn't work for them, so like why would they be joined? They can't do that. So basically, it really is a defendant dispute, and so they probably, even over the applicant's objection, they would still join you.
All right. I think we're right there at the cutoff mark. I tried to respond to as many questions as I could informally through the chat service, but again, anything else that comes up, feel free to let Lauren or myself know. We're more than happy to answer your questions as we go along.
Thank you both so very much. I think Allison said it perfectly. She said, thank you. This has been really informative. So thank you so very much for preparing this for us today. If you wouldn't mind, Lauren, while I go over some information really quick, will you go to your contact page so they can see your contact information?
Sure.
Today's PowerPoint presentation is available on our website under the training tab. You can register now for our September 20th webinar, which is going to be on Old Law, New Tricks with Don Barthel and Zane Uriberry. And I think that's all from me for today. I hope you all enjoyed today's presentation, and we look forward to seeing you next time. Thank you so much.
Thank you, everyone.